since everybody's so polite and quieted down right at the invited time. Good morning. Welcome to UC Davis School of Law and the Law Review Symposium on the Honorable John Paul Stevens. We are proud and honored to have you here. And I also want to welcome C-SPAN in America and the court's viewers from across the United States. We're hoping that it doesn't play at 2 in the morning at some point in time, that we get a nice Saturday afternoon perch. As part of this 40th anniversary of the dedication of Martin Luther King Jr. Hall, this symposium pays tribute to the career of Supreme Court Justice John Paul Stevens. Since his appointment in 1975, Justice Stevens has crafted a rich and intellectually powerful jurisprudence. We are graced today with a wealth of the best and brightest legal minds in the country, many of whom served as clerks to justice. They will analyze his work on the most difficult issues of our time, from terrorism to environmental protection, from statutory interpretation to administrative law. His remarkable jurisprudence and his role as the conscience of the Supreme Court richly deserves the careful study it will receive today. Now, we have an extraordinarily distinguished group of panelists, and I want to mention them at the outset and thank them all. We have Dean David Levy from the Duke University Law School, and formerly a United States District Judge for the Eastern District of California, and also formerly an adjunct professor at UC Davis School of Law. We have Jeffrey Fisher, co-director of the Supreme Court Litigation Clinic at Stanford. We have Jamal Green at Columbia. Linda Greenhouse, currently at Yale Law School and formerly the reporter for the New York Times covering the Supreme Court. We have Elizabeth Semmel, director of the Death Penalty Clinic at UC Berkeley. Cruz Reynoso, a former justice of the California Supreme Court. Andrew Stiegel from Seattle. Teresa Wynn Roseborough, former U.S. Deputy Assistant Attorney General. Kenneth McMaster of Santa Clara. Daniel Farber of UC Berkeley. Eugene Fidel, president of the National Institute of Military Justice. Deborah Pearlstein, research scholar at the Woodrow Wilson School at Princeton. And Catherine Watts of the University of Washington. I want to thank all the participants for being part of the symposium. I'd also like to thank our sponsors, the law firm of Boutin, Gibson, DeGisto, Hodel, Incorporated, Kirkland & Ellis, and King Hall Annual Fund. Last but not least, I would be truly remiss, and she arrived on cue, I would be truly remiss if I did not thank my friend and colleague, Professor Diane Marie Amon, an accomplished international law scholar, a former clerk of Justice Stevens, and the new director of the California International Law Center at UC Davis School of Law. This symposium is a result of her hard work and commitment. Thank you, Professor Amon. And without any further ado, we'll hear from Justice Stevens.
Dean Johnson, Dean Levy, and Professor Amon, friends and former law clerks, and people who are spending their valuable time attending this fine event, I want to welcome you and thank you for your part in all the proceedings. I want to start by explaining why I think Dean Levy has probably agreed to participate, or why he was invited. I don't know which I should say. But it's not, I don't think, because of his fine record as a district judge or the fact that his father was probably the finest attorney general that the country's ever had, or the fact that he's such a good scholar. The truth of the matter is that Dean Levy served as a law clerk at the Supreme Court for Lewis Powell some good many years ago, and I think that probably is the factor that has qualified him for participating in this welcome event. Similarly, I want to mention Professor Amon, who clerked for me a good many years ago, and I just want to mention 2 cases that she worked on because they, I think, are relevant to experiences that a good many of you have had in connection with your work at the court. One of them, the Green against Rock Laundry, or I don't remember the exact name of the case, involved a scrivener's error involving the construction of a federal rule of evidence that permitted impeachment, if read literally, of a plaintiff in a civil case because it merely provided for discretion in terms of what the judge could do in regulating the trial for the defendant. And it's a case in which was a clear scrivener's error. and we had the problem of figuring out what Congress actually meant when they drafted and enacted the rule. And Diane did more work on the legislative history of that particular provision than I can remember any other clerk having to do, and we came up with a result that neither of us was happy with, but which we thought was actually what Congress must have intended in a very awkwardly drafted rule. And that was typical of the kind of work that she did. Another example of a case she worked on was the Ward's Cove case, a Title VII case, in which the record was terribly important in thinking through the whole problem, and her work on understanding what was to be found in one of the records in a big record case was really remarkable and extremely helpful. And I mention that because I want to thank her and others in the audience who have served as law clerks in the past, not just for being here today and participating in this interesting proceeding, but for all the work that you've done over the years in different capacities that have been of immense help to me in my work. And finally, and specifically, I have to mention Dan Farber as the one clerk whom I identified in an opinion that I wrote. And I have before me the opinion in Hazelwood School District against the United States, 433 U.S., at page 318. I commend all of you to an examination of the footnote in that case, because I was talking about Dan. Again, I thank all of you for being here and for everything you've done for me in the past and for what you continue to do to serve our profession and our country as best you can. Thank you very much.
This is not intended to take issue with anything that the justice just said, but since he asked the question of why I was here, let me just say that I'm here because of my admiration and loyalty and affection for this law school. And I want to thank, on behalf of the panel, the law school, Professor Amon, Dean Johnson, and the members of the law review for inviting us here and being so hospitable. And then, like everyone else who's here in the audience and in the room, I'm here because of my deep admiration for Justice Stevens. He mentioned that there's something of a familial connection between the Levy family and Justice Stevens. I grew up in Chicago, as did Justice Stevens. We went to the same high school, but of course what's significant today is the fact that my father was Attorney General when Justice Stevens was appointed. And I remember at that time my father had been a law school dean, and he knew many prominent, eminent law professors at the University of Chicago and around the country, and many of them thought that this vacancy was something that they would very much like for themselves. And there was a good deal of pressure on my father at that time, and he because he knew so many of these people, and they were wonderful people, and they were friends of his. And he had a panel of law professors and others who were reading opinions by possible candidates, those who had been who were on the bench. And I remember him telling me that the opinions of John Paul Stevens, that Paul Bator had said to him, "Who is this judge on the Seventh Circuit? These opinions are truly wonderful. They're jewels." And so the appointment went forward, and I know that President Ford has said many times that it's one of the things that he did in office of which he is most proud. So it's a privilege to be here today. Our panel is to talk about Justice Stevens' concept of liberty, and it covers a great deal of ground because for Justice Stevens, the concept of liberty covers a tremendous amount of ground. He sees it as one of the elements of liberty is the right to be respected as a human being. And the right to be respected as a human being, as he sees it, covers a lot of territory, including a prisoner's control over his personal effects, a person's right to consult a lawyer and actually pay that lawyer a higher fee than a legislative cap might permit. And it covers, for example, the right to travel from one state to another. It covers, in Justice Stevens' view, personal autonomy over one's physical body. It covers freedom from arbitrary government action and restraint. And we have a wonderful panel here this morning to discuss some of these aspects of liberty that are so important to Justice Stevens and to his body of work. Our first speaker will be Linda Greenhouse, who is an eminence in the law. She is the Knight Distinguished Journalist in Residence and the Joseph M. Goldstein Senior Fellow in Law at the Yale Law School. As most of us know, from 1978 to 2008, she was the New York Times correspondent to the United States Supreme Court. Among her many honors, she has won the Pulitzer Prize in 1998 and the Goldsmith Career Award for Excellence in Journalism from Harvard's Kennedy School of Government. She's a member of the American Philosophical Society. She's a fellow of the American Academy of Arts and Sciences, and her biography of Justice Blackmun, Becoming Justice Blackmun, was published in 2005. The speaker after Ms. Greenhouse will be Professor Jamal Green. Professor Green is an associate professor of law at Columbia Law School, where he specializes in constitutional law and constitutional theory. He received his A.B. in economics from Harvard in 1999. He then was a reporter for Sports Illustrated for 3 years. With that preparation, he was ready for the Yale Law School, where he got his J.D. in 2005. I have a son at Yale, so that's just an in-joke. He was a very successful law student. He clerked on the Second Circuit with Judge Guido Calabresi, and then he clerked for Justice Stevens in 2006. He's a prolific writer, and he is most recently published both in the Yale Law Journal and the Georgetown Law Journal. Professor Elizabeth Semmel, at the end of our panel, is a clinical professor of law and the director of the Death Penalty Clinic at the Berkeley Law School. Before that, she was the director of the American Bar Association's Death Penalty Representation Project in Washington, D.C. She's submitted amicus briefs in a number of critically important death penalty cases in the United States Supreme Court. She regularly writes and comments on issues that affect the rights of the accused in criminal cases, with a particular focus on those who face the death penalty. And seated next to me is Professor Jeffrey Fisher. Professor Fisher is an associate professor at the Stanford Law School, where he co-directs the Supreme Court Litigation Clinic. He's one of the leading Supreme Court practitioners. He has argued and won the cases of Blakely versus Washington and Crawford versus Washington, and those are just his most recent successes. After a Ninth Circuit Court of Appeals clerkship, he clerked for Justice Stevens in 1998. Our order of battle here this morning is that each of our presenters will speak for 15 minutes on their topic, addressing some aspect of Justice Stevens' view of liberty. And then we will have a bit of a discussion among the panelists, and we'll invite the audience as well to participate in that discussion. So we'll begin with Ms. Greenhouse.
I'm delighted to be here. My topic is Justice Stevens and abortion. And my challenge is to boil down a much longer paper into my allotted 15 minutes, and I'm going to rely on Dean Levy to give me a heads up as to how I'm doing about that. John Paul Stevens was the first new justice to arrive at the Supreme Court after Roe against Wade. Not quite 3 years had passed between the decision in the abortion case and the Senate's vote of 98-0 on December 12, 1975, to confirm Justice Stevens to the seat vacated by Justice William O. Douglas. The nomination had sped through the Senate. The vote took place after 5 minutes of discussion on the Senate floor, a week after the close of the 3-day confirmation hearing. And only from the perspective of today after Roe against Wade has for so long been the centerpiece of so many Supreme Court nomination and confirmation debates, does it appear remarkable that no senator asked the nominee a single question about abortion? Equally surprising today is the lack of appreciation generally of the significant role that John Paul Stevens has played nearly from the beginning of his Supreme Court career in the court's developing abortion jurisprudence. So my purpose is a modest one. It's to give Justice Stevens his due as a major contributor to the contours of the abortion right that exists today. Indeed, as an indispensable strategist in the preservation of that right at its moment of greatest need. Much of the evidence for my conclusion about this is hiding in plain sight in the pages of United States reports. For the backstory to the cases in which he participated, I've relied largely on the collected papers of Justice Harry Blackmun at the Library of Congress. And that essential resource enables us to track a relationship between the two justices that began in distance and some wariness and ended in a solid alliance in evolution that reflected Justice Stevens' own deepening engagement with the right to abortion and his commitment to preserving it. From a pro-choice perspective, from Harry Blackmun's perspective, Stevens' tenure did not begin auspiciously. Barely 3 months after he joined the court, the justices heard argument in Planned Parenthood of Missouri against Danforth, a challenge to one of the numerous statutes the states enacted in the immediate wake of Roe against Wade to limit access to the right that the court had announced. This Missouri law required a married woman seeking an abortion to obtain the consent of her husband and an unmarried woman under the age of 18 to obtain the consent of at least one parent. In an opinion by Justice Blackmun, the court declared the statute unconstitutional in all respects. Justice Stevens agreed with the spousal consent provision, agreed that that should be struck down. But he voted to uphold the parental consent requirement. Quote, "The state's interest in the welfare of its young citizens is sufficient, in my judgment, to support the parental consent requirement," he wrote in his separate opinion. He said that a state legislature was entitled to conclude, quote, "that most parents will be primarily interested in the welfare of their children," and further that the imposition of a parental consent requirement is an appropriate method of giving parents an opportunity to foster that welfare by helping a pregnant, distressed child to make and implement a correct decision, unquote. Needless to say, Harry Blackmun didn't like this very much. Barely 6 months later, the court was wrestling with another post-Roe dilemma, whether the government was obliged, either by statute or the Constitution, to pay for abortions for women who were too poor to pay for one themselves. Once again, Blackmun could take little comfort in the performance of his newest colleague. Stevens joined a 6-3 majority that rejected the claim, both on constitutional and statutory grounds. Nonetheless, there was evidence, at least from Blackmun's point of view, that John Paul Stevens was not a lost cause. All three, this was a trio of cases, all three went to conference in January 1977, and Blackmun's conference notes indicate that Stevens' vote was neither reflexive nor untroubled. He said that this one of these cases, Mayer against Roe, which presented the broadest constitutional issue, that could the state, a state that used Medicaid funds to pay for childbirth for poor women, the statute said, did not have to pay for abortions for poor women who didn't want to continue the pregnancy. And Blackmun's extensive conference notes indicate that the court's discussion was lengthy and intense. This is what Stevens said in Blackmun's shorthand: "Important not to overrule Roe. Equal protection, difficult, but state has an interest and Roe so recognizes. But legislative arguments, not so overwhelming. Impact of Roe is eaten away. Will the legislature make the necessary decision? I'm concerned whether the democratic process will survive," unquote. That was what Stevens said to his colleagues in the closed-door conference. So the education of John Paul Stevens on abortion had begun. A pattern quickly emerged in the court's abortion docket, the one that would persist really until the present day. Every time the court upheld an abortion restriction, jurisdictions around the country would quickly adopt similar restrictions, and some would go a little bit further just to test the waters. Every time the court struck down an abortion restriction, jurisdictions would regroup and come back with a slight modification that just might pass muster. The result has been a steady stream of cases presenting the justices with the seemingly endless ways in which For example, parental involvement in a minor's abortion decision might be mandated by the government. One such variety reached the court in 1979, a case from Massachusetts, Bellotti against Baird. The state law, as authoritatively construed by the Massachusetts Supreme Judicial Court, required a minor to obtain consent of both parents or of a judge who was authorized to grant permission, quote, for good cause shown. Conversely, the judge was authorized to withhold consent upon finding that the abortion would not be in the minor's best interest, even a minor who was deemed capable of making an informed choice, and indeed one found to have made an informed choice. In other words, the judge could just overrule that. With only Justice White dissenting, the court voted 8-1 to affirm the Massachusetts SJC's judgment that the statute was unconstitutional. And this case marked John Paul Stevens' emergence from the shadows into the limelight of the court's abortion jurisprudence. Justice Blackmun's notes from the conference discussion indicate that Stevens was deeply interested in the case. Blackmun's transcription of Stevens' comments is twice as long as that of any other justice. As the junior justice, Stevens spoke last at the conference. I wrote in Danforth, that early Missouri parental notice case, he began, wasting no time in explaining how he proposed to reconcile that vote 3 years earlier with the one he was about to cast. He noted that while the Missouri law had required the consent of one parent, the two-parent law in Massachusetts was, he said, very, Blackmun's notes, DIF, so I don't know whether diff was difficult, different. In any event, he was clearly able to distinguish the two. Despite the strong majority for affirmance, the court didn't have an easy time with this case. Chief Justice Berger assigned the opinion to Lewis Powell, who circulated a lengthy draft indicating how a legislature might go about basically saving the statute, crafting a constitutional parental involvement statute. But Stevens was not on board that. On June 7, 1979, Blackmun's law clerk on the case informed his justice of recent developments. Stevens was circulating his own draft, the law clerk said, and it was a surprise. Stevens was objecting to any form of judicial veto, disdaining any attempt to provide guidelines for the state in drafting a parental consent statute. The law clerk said to Blackmun, I understand from his clerk that JPS is not sure that a court should ever be allowed to determine whether a minor is immature or mature, and is not sure that a court should even be allowed to determine whether an abortion is in the best interest of an immature minor. The law clerk told Blackmun that there was movement toward the Stevens approach of a narrow, clean, unobjectionable opinion. And the memo continued. I understand that there is considerable interest in the liberal camp, Justice Marshall, Justice Brennan, and now JPS, in the possibility of pulling 5 votes together behind JPS. John Paul Stevens in the liberal camp, in the eyes of a Blackmun law clerk, certainly this was the real surprise. Undoubtedly, that judgment reflected not only the case at hand, but contemporaneous non-abortion developments within the conference. But the appearance of the word liberal in the abortion context within the Blackmun chambers was highly significant. Blackmun, along with Brennan and Marshall, did in fact migrate toward the Stevens concurrence in this case. They abandoned the Powell opinion, sorry, Dean Levy, which thus became an opinion for a 4-member plurality. And Stevens wrote, it is inherent in the right to make the abortion decision that the right may be exercised without public scrutiny and in defiance of the contrary opinion of the sovereign or of other third parties. This was hardly the justice who had argued in Danforth that the state was entitled to assume that most parents would act reasonably and responsibly in deciding whether to permit their daughter's choice to terminate a pregnancy. And when the public funding issue returned to the court a year later, Stevens dissented from the court's decision to uphold the Hyde Amendment, a federal budgetary measure that limited, in most cases prohibited, the use of federal Medicaid money to pay for abortions, even abortions deemed medically necessary. Stevens wrote a separate dissenting opinion, noting that a poor woman who would ordinarily be entitled to Medicaid coverage for all medically necessary care was being denied the ability to exercise her constitutional right. So these developments, I think, show that early on, back in the 70s, Stevens was working continuously to find a place to stand on the issue of abortion, one that made sense to him among the roiling waters of the court's developing abortion jurisprudence. As with other aspects of the court's docket within the boundaries of stare decisis, and Liz Semmel will certainly, I'm sure, talk about this with respect to the death penalty, He was never willing to take for granted that he had been right in the past without thinking the problem through in each subsequent iteration. The dynamic quickly began to change when Justice O'Connor came on the court, replacing Justice Stevens, and that really threw the whole future of the right to abortion into some doubt. And a large part of my paper, which I'm going to condense quite drastically, shows that Justice Stevens reached out to Justice O'Connor and worked with her, not always successfully, but little by little, gained her trust. They were on the same page. And this really came to fruition in 1992 when Roe against Wade, when the court's adherence to Roe against Wade faced a moment of truth in the Casey case, Planned Parenthood against Casey. And in this case, and I just want to skip ahead here and find the part that is crucial. Excuse me. Stevens played a strong role in framing the question that was going to be granted in this case, trying to narrow the question to limit the chance that the court would actually use the case to overturn Roe. And the essential outline is now, I think, pretty well known, how the three justices, Sandra O'Connor, Anthony Kennedy, and David Souter, worked together to craft an opinion that would adhere to the basis of Roe against Wade. As soon as Stevens saw this draft, he sprang into action and began running interference between Harry Blackman, who was very distressed by this case and was writing a very fierce dissent, and the trio, with the ultimate goal of producing an opinion, or as much of an opinion for the court as could be produced. He wrote to them, he said, "Your opinion is impressive, you're to be congratulated," but he suggested a complete reordering of the trio's opinion that would start with what was right about Roe against Wade instead of the draft that they had produced, which started with what was wrong with it and kind of built up to what should be saved of it. And this is how the Casey case came out. It enabled Blackman to sign, Stevens to sign with the three, the first 26 pages of the opinion, which adhered to the basic outlines of Roe against Wade. Just finish up here very quickly. Justice Stevens had only one more opportunity to influence the course of the court's course on abortion. In 2000, the court struck down Nebraska's partial birth abortion prohibition by a vote of 5-4. Kennedy voted in dissent. And the challenge to Stevens, who had the assigning power as the senior associate justice in the majority, was to hold Sandra O'Connor. He assigned the opinion to Breyer, whose opinion in Stenberg against Carhart that was produced here was almost completely devoid of rhetoric. It read more like an article from a medical journal, and it did the trick. It held O'Connor. 7 years later, when a nearly identical federal abortion ban came before the court in Gonzalez against Carhart, O'Connor was off the court. With her successor, Samuel Alito, voting the other way, Kennedy wrote the majority opinion to uphold the Federal Partial Birth Abortion Act. Stevens did not write separately, permitting Justice Ruth Bader Ginsburg to speak powerfully for all four dissenters. It was, in a sense, a final strategic calculation from a justice whose influence on the Supreme Court's abortion jurisprudence had for so many years depended not on the volume of his voice, but on the quality of his judgment. Thank you.
Professor Green.
Thank you, and good morning, everyone. It's appropriate that Linda finish up with Gonzalez versus Carhart, as it will become evident that case is pretty important to what I'm talking about as well. I've titled my talk and the paper that will eventually emerge from it, The So-Called Right to Privacy. And my basic argument, it's kind of a quirky argument, is that although we still enjoy a number of rights whose origins lie in a constitutional right to what's been called fundamental decision privacy, there's no longer any especially relevant doctrine of constitutional privacy. I'm going to argue that this result, the erosion of the doctrine of fundamental decision privacy without much erosion in the content of the rights the doctrine is meant to protect, is precisely the result that Justice Stevens has long advocated, and moreover, is precisely the result that those who would seek to protect those rights should want. I'll start with my basic premise that the doctrine of constitutional privacy has faded into something of an irrelevance. Then I'll talk a bit more about how that comports with the views of Justice Stevens. And finally, I'll say a word or two about why I think this might matter doctrinally. The expression that is the title of the talk, the so-called right to privacy. It first appeared in a New York Court of Appeals opinion called Robertson versus Rochester Folding Box Company. It wasn't about anything so grand as the right to make fundamental decisions about the intimacies of life. It was about a woman who was quite upset that her likeness had been used in an advertisement for a flour mill. And the New York Court of Appeals judge in that case wrote the majority opinion, Alton Parker. He used the expression, the so-called right of privacy, and it's noteworthy not so much because of the content of the right he was trying to protect, but because, at least for our purposes, he's the first in a long line of distinguished people to use that label, the so-called right, to describe or to demonstrate their distaste for the right to privacy. John Roberts, now Chief Justice of the United States, used the term in 1981 in a memo to William French Smith, who was the Attorney General at the time. Ed Meese's 1988 Justice Department Guidelines on Constitutional Litigation used the term, the so-called right to privacy. Justice Scalia used that term in his dissenting opinion in Lawrence versus Texas. And believe it or not, our beloved Justice Stevens used that term in a 1975 opinion he wrote for a panel of the Seventh Circuit in Porter versus Fitzgerald versus Porter Memorial Hospital. I want to suggest that in large part because of Justice Stevens' work on the court, the right to privacy now exists more in these kinds of criticisms and dissents than it does in majority opinions. Now, when I say that, I don't mean that there's no constitutionally relevant right to privacy. Of course, the right to prevent unauthorized use of one's likeness or image, the right to be free of government eavesdropping, the right to associate without unjustified governmental interference. These are still things that are, at least the latter two categories, are still constitutionally protected to some degree or other in the Fourth and First Amendments. That's not quite what I'm talking about. I also don't mean that the concrete substantive rights that we get from the right to privacy, sort of paradigmatically, the right to an abortion, the right to contraception, the right to, broadly speaking, a private consensual sexual relationship in the home, that these are not, I don't mean these are not protected. They certainly still are. But my submission is that they're not protected because of a constitutional right to privacy, at least not anymore. The right to abortion, most recently defended by the dissenters in Gonzalez against Carhart, Justice Ginsburg's opinion for the court, joined by, or her dissenting opinion, joined by Justice Souter, Justice Stevens, and Justice Breyer, discusses Planned Parenthood versus Casey, talked about the origins of the constitutional right to an abortion, but says, quote, legal challenges to undue restrictions on abortion procedures do not seek to vindicate some generalized notion of privacy, but rather they center on a woman's autonomy to determine her life's course, and thus to enjoy equal citizenship stature. The other kind of big category of cases that are paradigmatically associated with the constitutional right to privacy, what might be called the right to sexual privacy cases, the most prominent, most successful being Lawrence against Texas, also don't, at least anymore, speak in terms of privacy. Bowers versus Hardwick, which Lawrence overruled, spoke about the right at issue in that case as an aspect of privacy. Justice White's majority opinion in that case. Justice Blackmun's dissenting opinion in Bowers versus Hardwick began by saying the case, quote, is about the most comprehensive of rights and the right most valued by civilized men, namely the right to be let alone. Here echoing the famous formulation from the 1890 Harvard Law Review article of Samuel Warren and Louis Brandeis, and that was about the privacy tort. Lawrence majority opinion by Justice Kennedy sought specifically to distance itself from that conception of the right at issue. Justice Kennedy's opinion rather studiously avoids referring to the right at issue in privacy terms, and he cites favorably not to Justice Blackmun's dissenting opinion from Bowers, but to Justice Stevens' dissenting opinion. In Bowers versus Hardwick, Justice Stevens wrote, in pertinent part, that, quote, individual decisions by married persons concerning the intimacies of their physical relationship even when not intended to produce offspring, are a form of liberty protected by the Due Process Clause of the 14th Amendment. Moreover, this protection extends to intimate choices by unmarried as well as married persons. Justice Kennedy's majority opinion in Lawrence says that this analysis should have been controlling in Bowers and should control here. So thus, as understood by the majority in Lawrence, the right to make personal decisions regarding one's intimate life is protected not as part of or an aspect of the penumbral right to privacy that emerges from Justice Douglas's opinion in Griswold, but as an aspect of the liberty directly protected by the text of the Due Process Clause of the 14th Amendment. Justice Douglas's privacy right then, I think, lives on only in the minds of its critics. It's entirely understandable that Justice Kennedy would have turned to Justice Stevens to articulate that view. Justice Stevens has repeatedly emphasized that treating fundamental decision privacy as fundamental decisional rights as an aspect of privacy is a mistake. And in that opinion in Fitzgerald versus Porter Memorial Hospital for the Seventh Circuit in 1975, this was a case having to do with whether a husband had a right to be present in the delivery room for the birth of his child at a public hospital, and Justice Stevens offered his view of what he then labeled the so-called right to privacy. He wrote, quote, "It is somewhat unfortunate that claims of this kind tend to be classified as assertions of a right to privacy. For the group of cases that lend support to plaintiff's position do not rest in the same privacy concept that Brandeis and Warren identified in their article in the 1890 edition of the Harvard Law Review. These cases do not deal with the individual's interest in protection from unwarranted public attention, comment, or exploitation. They deal rather with the individual's right to make certain unusually important decisions that will affect his own or his family's destiny." And that destiny term ends up showing up in the court's abortion jurisprudence later on. On this view, it is not merely that invoking the right to privacy seems like a bad fit for the rights at issue, but in fact that the right to privacy, or speaking in privacy terms, kind of trivializes the right at issue. Justice Stevens has said elsewhere, and Dean Levy referred to this earlier, that the right to liberty protected by the liberty of the Due Process Clause of the 14th Amendment is the right to be respected as a human being. He said that, for example, when he delivered the Cole Lecture at the University of Miami in 1986. That idea informs his view that certain liberty rights, certain aspects of liberty, are inalienable. And so, in Justice Stevens' view, substantive due process doesn't necessarily deserve the oxymoron label that it's acquired. Our freedom to make life choices that are vital to our self-definition is an aspect of our humanity, in Justice Stevens' view. And since government did not provide those rights, government cannot take them away. Substantive due process, he said in that Cole Lecture, means, quote, that individual liberty is primary. The government has to prove itself. I had thought it self-evident, he said, dissenting in 1976 in Meacham versus Fano, that all men were endowed by their Creator with liberty as one of the cardinal unalienable rights. It is that basic freedom which the Due Process Clause protects, rather than the particular rights or privileges conferred by specific laws or regulations. And that view that fundamental life decisions are protected not by a kind of penumbral right to privacy, but directly by the text of the Due Process Clause, is ironically the view taken by Justice White in his concurrence in Griswold versus Connecticut. And the reason it's ironic is because Justice White was, of course, staunchly opposed to the right to an abortion and the right to what he called in Bowers, the right to homosexual sodomy. Justice White's opposition to the rights that are, I think, currently protected by the liberty interest that Justice Stevens identified is, I think, important from a political economy perspective. I think it demonstrates something about the politics of methodology and the politics of substantive rights. The right to an abortion is supported by pretty decent majorities of the American people. The right to a private, consensual sexual conduct in the home, whether or not it's supported by majorities, doesn't have, at least any longer, a serious mobilized opposition. But the right to privacy, on the other hand, has been a source of political mobilization, particularly on the right. It was famously demonized by Judge Bork during his confirmation hearings in 1987. The notion of unenumerated constitutional rights has been the target and the foil, really, against which the textualist, originalist, methodological movement, of which Justice Scalia is part, has defined itself. And so I would suggest that protecting the right to an abortion and the right to sexual intimacy in the home without doing so under the rubric of privacy ends up both methodologically and substantively getting Justice Stevens right about where the American people are. I want to finish up by saying a couple of words about why I think this might matter. The difference between Justice Douglas's opinion in Griswold and Justice White's opinion in Griswold is subtle, and so it might seem perhaps a bit naive to suggest that this kind of small difference in constitutional doctrinal language would actually drive substantive rights in any way. And I agree that ultimately the sorts of rights that get protected by the Supreme Court are going to be determined by the political will of the American people and not by these sort of subtle doctrinal moves. But I do think that how one frames rights that one seeks to protect does matter a bit. I think it matters to the pace of change, and I think it matters to the institutional source of change. And so let me just take a couple of quick examples where I think framing might matter with respect to privacy versus liberty. The first is same-sex marriage, which is obviously a significant topic here in California as well as throughout the nation. The right to marry the partner of one's choice is quite an awkward fit for a constitutional right to privacy, if for no other reason than that marriage is emphatically non-private, and that's sort of part of the reason why there's so much controversy about this issue. But I do think that Justice Stevens's the way in which he articulates substantive due process fits quite comfortably with protecting the right to marry the partner of one's choice. The other example cuts the other direction. There's a circuit split presently between the 5th and the 11th circuits over the constitutionality of laws that prohibit the sale of sex toys. Now, that sort of issue, to the extent that one believes that there is a right to either purchase or use sex toys, I think fits more comfortably with the language of privacy than with the language of liberty. And indeed, I think it would rather trivialize the right recognized in Lawrence to apply it effortlessly to a right to use or to purchase sex toys. And sometimes I think that would demonstrate that sometimes a right can be strengthened by not extending it to something else. So framing the right to an abortion, the right to same-sex intimacy in terms of liberty directly protected by the text of the 14th Amendment, as opposed to as an aspect of privacy, while not without its pitfalls, is, I would suggest, a more defensible, a more intuitive, and therefore a sounder basis for constitutional protection. And Justice Stevens, I think, should be commended for his role in effecting that transformation.
Now we shift our gaze from personal autonomy as an aspect of liberty to freedom from undue or unreasonable restraint as an aspect of liberty in Justice Stevens' jurisprudence. Professor Semple.
Given the introduction, it will come as no surprise that my topic is capital punishment. And the piece, at least, is tentatively titled Reflections on Justice Stevens' Opinion in Bays versus Reese, Whose Evolution. Each of us was invited to bring to this symposium a perspective on Justice Stevens' jurisprudence that derives from our professional experiences. Mine is that of a capital defense attorney who has defended clients, defended the accused for more than 3 decades. I've had the enormous good fortune to be involved in a number of Supreme Court death penalty cases, and in preparing for these remarks, also had the occasion to benefit from the observations of former Supreme Court clerks. And in my teaching role, I must confess that I've had the occasion to become more reflective about the arc of capital punishment jurisprudence. Nonetheless, I continue to view opinions in death penalty cases through the lens of an advocate in at least two respects. First, I ask whether the decision advantages or disadvantages my clients. And second, I consider whether or not it advances the goal of abolition and addresses other broader systemic deficiencies that are in some form embedded in capital cases such as race discrimination, denial of adequate counsel, and barriers to justice. As many of you know, in 2006, Professors James Liebman and Larry Marshall, both former Stevens clerks, published an exhaustive article on the subject of Justice Stevens' death penalty jurisprudence. And they compared what they called Justice Stevens' nuanced, less is better approach to the death penalty with that of other members of the court who, unlike Justice Stevens, were among the 9 whose collection of separate opinions made up the decision in Furman against Georgia in 1972, and with the views of others who served with Justice Stevens since his appointment to the court in 1975. Now, I'm not going to use Jim and Larry's analysis as a rehash, but rather as a jumping off point to discuss what I think is actually not the capstone to Justice Stevens' death penalty jurisprudence, that is his concurring opinion in Bays. I wouldn't call it the capstone because while this is a symposium examining Justice Stevens' career to date, his career on the court has most certainly not come to an end. In April of last year, the Supreme Court issued its opinion in Bays, the case that established the test for determining whether a method of execution violates the Eighth Amendment's ban on cruel and unusual punishments and upheld Kentucky's lethal injection protocols. Justice Stevens concurred in the judgment, but I should say he concluded that the imposition of the death penalty represents, and I'm quoting, the pointless and needless extinction of life with only marginal contributions to any discernible social or public purposes, unquote, and therefore violates the Eighth Amendment. With these words, Justice Stevens became the 5th Gregg justice to declare capital punishment is unconstitutional under the Eighth Amendment. On a single day in 1976, the court issued Gregg versus Georgia and 2 companion cases approving statutes in Georgia, Texas, and Florida that had reenacted the death penalty under variations of a model of what had become to be seen as the Furman mandate, that the discretion of the sentencer must be guided so that the ultimate punishment is not imposed in an arbitrary or discriminatory manner. These 5 justices served together, that is the 5 Gregg justices who later declared the death penalty unconstitutional, served together between 1975 and 1987, and they are in order of appointment Justices Brennan, Marshall, Blackmun, Powell, and Stevens. So for those who look forward to the day when a majority of the court will reach the milestone of abolition, Justice Stevens' opinion in Bays is another highly visible marker along this road. So first, with a bit of retrospective, I'm going to offer some observations about the 2-year period between the publication of the Liebman-Marshall article and the decision in Bays. What might have led Justice Stevens to conclude that the narrowing of the death penalty could not address problems with the institution sufficient to avoid having to take what Liebman and Marshall called the more controversial step of declaring it unconstitutional? Second, why might Justice Stevens have selected Bays, the lethal injection case, to take this next step? And I note here that however others may characterize Justice Stevens' conclusions, my sense is that he would not call it controversial. Third, having taken this step, why did Justice Stevens concur in Bays rather than follow Justice Blackmun's example in Callens versus Collins of dissenting from any death penalty affirmance, dissenting from a denial of certiorari or denial of stay in capital cases? Justice Stevens knew, of course, that his concurring opinion, the outcome in Bays, put both petitioners closer to execution. Let me just note that I'm not going to, and I do not compare Justice Stevens' conclusion in Bays to the dissenting opinions of Justices Marshall and Brennan and Gregg, or Justice Powell's statement after his retirement that he regretted his decision in McCleskey versus Kemp and had come to believe that the death penalty ought to be abolished. I was going to say that time permitting, I'll discuss some of the broader implications of Justice Stevens' concurring opinion, but I think that time will not permit. So, one could argue that there's ample basis for optimism that Justice Stevens would in some manner someday come to the conclusion that Justice Blackmun reached in Callens, when he now famously wrote that he would no longer tinker with the machinery of death, and he concluded that the death penalty experiment has failed. It's notable that the Liebman-Marshall article begins with Justice Stevens' speech to the American Bar Association in 2005 on the occasion of the Thurgood Marshall Award. And in that address, Justice Marshall cataloged the serious flaws in the administration of the death penalty, wrongful convictions, inadequate legal representation, the process of death qualification, which produces guilt-prone juries and creates a risk that a fair cross-section of the community will not serve on a capital jury, and two aspects of the sentencing process that tip the scales in favor of death: judicial elections and victim impact evidence. But there are at least several reasons, independent of the folly of prognostication, why it would have been unwise for Professors Liebman and Marshall to have predicted that Justice Stevens would ultimately embrace Justice Blackmun's view. First, Justice Stevens' reservations about capital punishment were already well-known and long-standing when their article was published. More than a decade before Bayes, in another address to an American Bar Association group, he delivered a somewhat similar critique of the death penalty. Second, as Professor Amen has written, Justice Stevens has never hesitated to dissent based upon, quote, the value he places on transparency in judicial decision-making, unquote. Third, the thesis of Liebman and Marshall's article is not that Justice Stevens has been inching his way towards Justice Blackmun. It is rather that his nuanced position on the death penalty has actually triumphed in terms of public policy and legislation, even as it has been rejected by the court. And my read of the author's objective in writing the article is actually to persuade the current court to embrace Justice Stevens' less is more approach, that approach to capital punishment is achievable, and in their words, a promising, if only a partial cure. So since the 1980s, when a majority of the court abandoned this narrowing approach, Justice Stevens has been a vigorous and frequent dissenter, including those very years following Justice Blackmun's announcement in Callens. And his dissents have often centered on some of the very issues that precipitated Justice Blackmun's conclusion in Callens. Again, racial bias, intolerance of the risk, the intolerable risk of mistake, the court's retreat from narrowing, and the evisceration of habeas corpus, that is, the ability of federal courts to remedy constitutional error. So it would seem that the answer lies somewhere between 2006, the Liebman-Marshall article, and April of 2008 when Bayes was issued. We can look to Justice Stevens' public statements, which I've already described. We can also look to his dissenting opinions during this period. In Utecht versus Brown, where he again objected to the exclusion from capital trials of jurors who opposed the death penalty. We can look to Medellin versus Dredke, where he joined with Justices O'Connor, Souter, and Breyer in dissenting from the dismissal of a writ of certiorari and the termination of federal proceedings in a case that involved the Vienna Convention on consular relations. We can look to Shiro versus Landrigan, where he wrote a dissenting opinion joined by other justices, a decision and wrote, about the majority decision, that it can only be explained by its increasingly familiar effort to guard against the floodgates of litigation. Third, I think it must be noted that during this period, Justices Roberts and Alito joined the court. So before I offer some theories about Bayes, it's worth mentioning Justice Marshall's conviction expressed in Furman that as the population becomes more educated about capital punishment, support for the institution will lessen. And you might ask, have I met anyone who has said, the more I learn about the death penalty, the more passionately I support it? And that includes recent and current members of the court. We have statements by Justice O'Connor prior to her retirement from the court, raising serious questions about capital punishment, telling a group in Minnesota that where they do not have the death penalty, you must breathe a big sigh of relief every day. Justice Ginsburg's remarks about the inadequacy of counsel in capital cases. Justice Breyer, following Justice Stevens' lead in Lackey versus Texas, raising questions about the constitutionality of a death sentence when an individual spends decades on death row before execution. And in 2006, in Kansas versus Marsh, we have Justice Souter in his dissent talking about evidence of the hazards of capital punishment. One might ask whither Justice Kennedy, and since Jeff Fisher is going to talk about Kennedy in Kennedy, I'm going to leave those comments to him. So some theories about Justice Stevens' next step, that next step in Bayes. Does Bayes represent an evolution in Justice Stevens' thinking that narrowing, even if it could theoretically serve its intended purpose, would not be embraced by the post-Rehnquist court? Or was this an evolution in Justice Stevens' thinking to the effect that narrowing, even if adopted, would not decrease the danger of an arbitrary and discriminatory death penalty sufficient to pass constitutional muster? Or some of both and something more? And I would argue the latter, some of both and something more. And it seems to me that the something more is based on two consistent philosophies. The first, Justice Stevens' view of the Eighth Amendment, and the second, his view of the role of a judge. Regarding the first, Justice Stevens has said the Eighth Amendment contemplated changed response in response to changes in society. And that in deciding cases implicating the Eighth Amendment, the views that prevail today should be the views that are decisive. And in Atkins, quoting Coker, he spoke about the need in the end for justices to bring their own judgment to bear on the Eighth Amendment question. Justice Stevens' view of a judge is likewise evolutionary. At a symposium at Fordham Law School held days before the Senate's confirmation of now Chief Justice Roberts, Justice Stevens said, I know that I, like most of my colleagues, have continued to participate in a learning process while serving on the bench. So I think it's fair to say that Bayes is not the radicalization of Justice Stevens. It is about his education because of his openness to realizing that applying the same legal principles that brought him to one view today leads him to another. I'm not going to have time to talk about why Justice Stevens chose Bayes, except to say that I think, not surprisingly, the reasons are transparent in the opinion. That after he goes through his description of the three sort of pillars of capital punishment, three rationales of capital punishment, reasoning, the functions of deterrence, retribution, and incapacitation, in talking about retribution, he deals with the fact that the increasing use of less painful methods of execution, while appropriate and required by the Eighth Amendment, actually undermine that very premise which the public approves of. And I want to conclude by commenting that I think what we should not make of Justice Stevens' concurring opinion in Bayes. In particular, he talked about the questions that remain open for the future. I think we need to note the fact that Justice Stevens has not followed Justice Blackmun. He has not dissented from denials of stay. He has not dissented from denials of cert, though that is not his want. And he has not even dissented in cases where he agreed with the judgment, such as Kennedy, but would have, if he were Marshall or Brennan, dissented based on his conclusions about the death penalty. Thank you.
Thank you. It's a wonderful privilege to be here today and to get to spend a day thinking about Justice Stevens and honoring his work. As a law clerk for the Justice about a decade ago, I spent a lot of my time working on criminal cases as it happened. which turned out to be a tremendously formative experience for me, and one that continues to this day with my work both as an academic and as an advocate on criminal procedure and criminal justice issues in the court. One of the things for me personally, the only thing that has turned out to be unfortunate about the privilege I've had to argue in front of the court and in front of the justice, most recently in the Kennedy case, is that that turns out to be the only interactions I've had with him recently, because the justice, ever careful with ethics, is I think appropriately uncomfortable having conversations with lawyers and even law clerks when their cases are pending before the court. So I've been limited over the last several years to seeing the justice from the other side of the bench, which I can say is itself an extraordinary privilege and thrill, and one that I can certainly remember my first couple of arguments in the court. And I think every time I was particularly pressed or particularly nervous, I just instinctively looked at Justice Stevens for reassurance. And so it's a privilege to come here today and talk about his work in the realm of criminal procedure. And particularly, I wanted to focus on the right to jury trial. In 1968, in Duncan against Louisiana, which is the case in which the Supreme Court held that the jury trial right applied to the states, the court, but this is obviously before Justice Stevens was on the court, wrote a really soaring opinion and an homage to the right to jury trial. And among other things, the court said that the right reflects a fundamental decision about the exercise of official power, a reluctance to entrust the plenary powers of life and liberty of the citizen to one judge or to a group of judges. And the court further explained that the right to jury trial is the fundamental protection against arbitrary rule or oppression from the government. Over the past several years, roughly the past decade in particular, we've seen a reemergence and a refocusing of attention on the right to jury trial and what it means and why it's important. In a line of cases that really began with Justice Stevens' opinion in Apprendi against New Jersey in 2000 and has been punctuated since by other opinions, Ring against Arizona in 2002, Blakely against Washington in 2004, and the United States against Booker in 2005, the court has held that the right to jury trial applies to facts that even if a legislature does not designate as part of the crime, nonetheless affects the defendant's punishment, and in particular increases or exposes the defendant to increased punishment. And a lot has been written about these cases, and in particular about the somewhat curious majority in these cases. The core majority in these cases have been a collection of 5 justices, Justice Stevens, Justice Souter, and Justice Ginsburg, and then on the other side of the bench, so to speak, Justice Scalia and Justice Thomas providing the 4th and 5th votes in these cases. And to the extent that critics and academics have discussed particular people in the majority, a lot of the focus has been on Justice Scalia. And I think perhaps because he's written a couple of these opinions, also perhaps because it might be a little more surprising to find Justice Scalia honoring the rights of criminal defendants than Justice Stevens and those in the more liberal camp of the court. But today I want to suggest, I want to talk about Justice Stevens' particular views on the court with respect to the right to trial by jury, and suggest that he actually has a distinct view that is tremendously important. And as I do that, it just reminds me of one story when I was a law clerk, and Justice Stevens came back from a conference in which we learned that he was going to write the majority opinion, and then he looked at the law clerks as we would sit around the table and said, and Justice Scalia is going to write the dissent. And then he kind of turned toward us with a little twinkle in his eye and said, "That's okay, I can take his heat." So these are 2 people, especially with the cases that Jamal and Linda have talked about, are often polar opposites. But here they are on the same side, but nonetheless, I'm going to suggest to you today, have 2 very different views of the right to jury trial. And in addition to spelling out, giving Justice Stevens, as I think Linda well put it, giving credit where credit is due for his work in this field, I'm going to talk about his distinct view and why I think it's important and how I think it's different than the Justice Scalia view of the right to jury trial. So first, to make out my claim for Justice Stevens' effect in the evolution of the right to jury trial, let me turn to the years after Duncan's against Louisiana, where Justice Stevens joined the court. And for several years, there was actually very little that the court had to do with the right to jury trial. But as we moved into the 80s, there became more and more legislative action involving the right to, involving sentencing procedures and ratcheting up sentences and identifying particular facts and identifying particular kinds of actions that would expose defendants to particular kinds of punishment. And so the court's first introduction to this problem came in a 1986 case called McMillan against Pennsylvania. And the issue in that case was whether using a handgun, the finding that the defendant had used a gun in the commission of a crime, which led to a 5-year mandatory minimum sentence, was something that the defendant had the right to require the jury to find beyond a reasonable doubt, or on the other hand, whether the trial judge could simply make the finding on his or her own after trial by a preponderance of the evidence. In an opinion by William Rehnquist, the court rejected the defendant's claim. And Justice Stevens wrote the sole dissent in that case, in McMillan. And I want to read you a few lines from that dissent. Justice Stevens said, "It would demean the importance of the reasonable doubt standard in the jury trial. It would demean the Constitution itself if the substance of the standard could be avoided by nothing more than a legislative declaration that prohibited conduct is not an element of a crime. A legislative definition of an offense named assault, for example, could be broad enough to encompass every intentional infliction of harm by one person on another. But surely the legislature could not provide that the only fact that must be proved beyond a reasonable doubt, and then specify the range of increased punishments if the prosecution could show by a preponderance of the evidence that the defendant robbed, raped, or killed his victim during the commission of the offense." So here Justice Stevens for the first time articulates a vision of the jury trial right that doesn't simply say whether the defendant gets a jury or not. It says when the defendant gets a jury, and lays down an idea that the legislature cannot manipulate the defendant out of that right. 4 years later, the Supreme Court had another case along these lines called Walton against Arizona. And the issue in Walton was involved capital punishment in Arizona. And the question was whether aggravating facts that were necessary to impose the death penalty needed to be found by a jury beyond a reasonable doubt. Here again, the court rejected the claim, including Justice Scalia rejecting the claim. And here again, Justice Stevens wrote a sole dissent in the case. And one line of his dissent was, "Even if the unfortunate decisions previous to this one fell one step short of the stride the court takes today, it is not too late to change our course and follow the wise and inspiring voice that spoke for the court in Duncan." So that was 1990. And as I told you at the top, 10 years later in Apprendi in 2000, Justice Stevens actually wrote an opinion for 5 justices holding exactly what he had told the court it was not too late to hold in Walton, and exactly what he advocated for in McMillan. He said the right to jury trial, along with the right to have facts that affect your sentence, are rights of surpassing importance. And he wrote a really landmark opinion for the court, declaring that the right to jury trial applies to facts that subject defendants not just to some kind of punishment, but to particular kinds of punishment. And 2 years later, the other shoe dropped on Walton itself. In the Ring case, 7 justices on the court voted to overrule Walton. And in thinking about this, it reminds me of the stories that many of us heard from the justice himself on the court, and that we've heard in the popular press about William Rehnquist when he joined the court at a similar time as Justice Stevens, and how he was often what was called the Lone Ranger, writing solo dissents on the court in 8-to-1 cases that later Chief Justice Rehnquist, as the chief, was able to put together majorities for the views that he espoused in solo dissents in his early days on the court. And here we have an example, and I think a rarely thought of example, of Justice Stevens doing exactly that. And if I could give Justice Stevens a special piece of credit for this, I think we could give him a special credit for achieving that, not with much help from appointments from presidents. This was true power of persuasion within the court, not simply a change of personnel on the court. And in following Ring in 2004 and 2005, the court brought this right to full fruition in Blakely and the Booker cases, applying the right to jury trial to sentencing guideline regimes. Now, even though I just said the court really articulated on some levels a robust right to jury trial in the Booker and Blakely cases, Booker being one that Justice Stevens wrote and Blakely being one that Justice Scalia wrote, there's nonetheless a strong criticism that is often voiced not just in the dissents in these cases, but also in the press and the academy and among lawyers, that the right to jury trial as it exists even in these newer cases is still not all it claims to be. It's overly formalistic, and in one that even though is aimed at curbing the effects of legislative drafting is nonetheless extraordinarily susceptible to legislative manipulation through things like mandatory minimum sentences and other wide ranges that still leave judges a great amount of sentencing discretion. And I think the principal case that gives rise to this criticism is one that the court decided also in 2004, Harris against the United States. And in the Harris case, the court considered another mandatory minimum provision and it considered the question whether the fact necessary to trigger that mandatory minimum was subject to the newly articulated Apprendi rule. In other words, the court considered for itself whether it should overrule the McMillan case. And in a 5-4 vote, the court actually declined to do it. Justice Scalia joined the majority opinion in that case, declining to extend the jury trial right to mandatory minimum findings, leaving it only to findings that increased the defendant's exposure to a higher sentence. Justice Stevens was in the dissent, but assigned the dissent to Justice Thomas in that case. So I think this is the case that really exposes the differences in approaches between Justice Scalia's view of the right to jury trial and Justice Stevens' view of the right to jury trial. The Scalia view of the right to jury trial, I think, is almost a separation of powers view. Justice Scalia, I think, sees the right to jury trial as he put it in Blakely, it's something that ensures the people's control over the judiciary. And so when people say it's really surprising that Justice Scalia is supporting the accused in these cases, I'm not sure he's supporting the accused as much as he's supporting and advocating a particular vision of the separation of powers. And it's one that, in his view, if we assign the power, decision-making power to particular people, then liberty and protection will follow from that. Now, the problem with the separation of powers approach to the right to jury trial is that it leads itself to formalism. And Justice Stevens, when he's written opinions and he's talked about this, I think has a much more functional, substantive view of the right to jury trial. So let me, in my final passage of one of his opinions I want to quote to you, let me quote again from his dissenting opinion in McMillan, where he says, "It's true, as the court points out, that the enhanced punishment is within the range that was authorized for any aggravated assault. That fact does not, however, minimize the significance of a finding of a visible possession of a firearm, whether attention is focused either on the stigmatizing or punitive consequences of that finding. The finding identifies conduct the legislature specifically intended to prohibit and to punish by a special sanction. And in my opinion, the constitutional significance of the special sanction cannot be avoided by the cavalier observation the majority makes that simply ups the ante for the defendant. No matter how culpable petitioner in this case may be, the difference between 11 and a half months, which is what the judge had said he would have given him but for the mandatory minimum, and 5 years of incarceration merits a more principled justification than the luck of the draw." So for Justice Stevens, the right to jury trial is really a functional being that is aimed at prohibiting legislatures, whether purposefully or unintentionally, for circumventing the right to trial by jury. And so why does he have this distinct vision? And I think this is the thing that gives us the insight into Justice Stevens here. Many of us say oftentimes that Justice Stevens is the quintessential common law judge. Common law judges, as opposed to more rule-bound judges, don't simply define and extend rules by their terms, irrespective of the consequences. And they don't do that just for the sake of defining and preserving rules. So for Justice Stevens, liberty is not about formalism, quite the contrary. It's not about structure of government. What liberty is about is individuals. And it's about the individual's protection against arbitrary or oppressive governmental actions. In other words, the right to trial by jury is the right that the defendant has to have his peers decide whether or not he is guilty of something and should be punished in a certain way. And so while I'm happy to sit here today and talk about Ring against Arizona, which overturned Walton and adopted Justice Stevens' solo dissent, in Harris, the court fell one vote short of that. And so I think my parting wish today would be that while Justice Stevens is still on the court, I think it would be a wonderful event for his dissenting opinion in McMillan to be adopted by a majority. And there's reason to believe it's possible. Concurring in Harris, Justice Breyer said, I agree with the dissenters in this case that the right to jury trial as articulated in Apprendi does apply in these circumstances too, because otherwise it wouldn't make any sense. But I'm not willing yet to sign on to Apprendi. So maybe Justice Breyer, or maybe a new justice, will be ready to sign on to Apprendi and to overrule the Harris case, because I think Justice Stevens himself has certainly not given up the cause. There was a case this year called ICE against Oregon, or Oregon against ICE, which involved a version of the Apprendi rule. And Justice Stevens, in oral argument, brought up McMillan yet again and asked the advocate and one of the advocates whether he thought McMillan was rightly decided. And this is what we call in the trade a softball question. But the advocate gently said, no, it would be wonderful if the court overruled McMillan. And so I'll leave you with the wish that while Justice Stevens is on the court, maybe that'll actually come to pass.
Linda, let's go back to you for a moment. You mentioned that Justice Stevens didn't get a single question about Roe v. Wade when he was confirmed by the Senate in 1975. Is that consistent with your understanding of what was going on at the period, or was that anomalous? What is your view?
Well, I think it shows us what was going on at the period, which was that there was a long kind of latency period between the opinion in Roe in January of 1973 and the latching onto it as the social mobilizing cry on the right that coincided with the rise of Ronald Reagan. And so Stevens comes on the court in that period where the right really had a lot of other fish to fry at that time, welfare and other kind of family values issues, and abortion hadn't yet become the horse to ride. And it's very illuminating. I mean, in fact, when I looked at his confirmation hearing transcript for this project, just looking for how he answered questions about Roe, I was so surprised to find that there weren't any questions that I went back and read it 3 times because I thought I was missing them. But then, I realized that it just reflected the times, and that's one thing. I'll just elaborate it for a second. That people kind of diss the Senate confirmation hearings for judicial nominees because they're so kind of scripted and formulaic, and these days you never get an answer and so on. But they really are a window into the issues that are motivating the politics of the country at any one time, because that's what the senators' questions reflect. So that tells us that abortion was not one of those issues in 1975.
I think I'm correct in stating that he also didn't get a single question about capital punishment in his confirmation hearings, and he's written about the fact that he didn't get a single question on that subject.
I mean, both, it seems quite remarkable from our vantage point. Now, I wonder, Jamal, you're sort of a student of public attitudes toward the Constitution. That's one of the areas in which you like to write. I mean, do you have reflections on how it was that the sort of the opposition to abortion built up steam, and whether your view that the basing the right in part on a right of privacy may have contributed to the opposition? Interesting.
Well, I think that there are a whole host of factors that I think led to the uptick in, or the I think association of the abortion right with evangelical Christianity, which I think, and the political mobilization of that group didn't happen quite as much until the 1980s. But I also think that methodology in itself became a strategy of the right during the 1980s. And I think it was, the Federalist Society is part of that. I think the Justice Department made a series of quite deliberate decisions about, rather than, you mentioned using confirmation hearings as a window into what society is thinking about. When you look at Justice O'Connor's hearings in 1981, they were talking all about jurisdiction stripping and the constitutionality of jurisdiction stripping. They weren't talking about these sort of methodological battles that happened much later, because the strategy for attacking the Warren Court, basically, or the Warren and Burger courts, was different at the time. And so I think somewhere in the mid-1980s, enough people on the right sort of settled in a strategy of attacking those decisions using a strategy of methodology. And so the right to privacy, although certainly it had been attacked before, it was attacked by John Hart Ely in his famous article right after Roe versus Wade. But there was mobilization around originalism and around textualism that I think made the right to privacy. It weakened it even among its proponents, including or its putative proponents like Justice Stevens and other people in the kind of liberal camp.
Just to go back to you, Linda, for a moment. Some of the writing about the Supreme Court, some of the popular writing, tends to argue, at least rhetorically, that the court is secretive and the hearings of the court are not televised. But in fact, as you've discovered, the papers of the court actually are remarkably available. I mean, the fact that you have this, you have the Blackmun papers, and that they cover actually fairly recent events on the court, and that the court, of course, has to explain itself in written opinions. In one sense, I think you could make the argument that the court is one of the most transparent institutions of government that we have.
Well, yes. I mean, I've actually argued that for quite a while, that the court's the only institution that really does have to explain itself. And, if you look at Congress, where agendas just disappear if you turn your eyes away, and no fingerprints are left on anything, and nothing happens at the court except that they have to sign their name to it. But there are not going to be another set of papers like the Blackmun papers contemporaneously available. And what was remarkable about the Blackmun papers, under the terms of his will or his deed of gift to the Library of Congress, the papers were going to be open 5 years after his death, and he lived for 5 years after he retired. So it was a 10-year lag. And what was remarkable about that 10-year period was, other than Stephen Breyer replacing Harry Blackmun, there was no turnover on the court. And so when the papers opened in 2004, it was the same court. And he had no reason to anticipate that. That was the longest period of time without a change in membership of the court since the 1820s. It was a real historical anomaly. So that's never going to happen again, even if the current justices had not committed themselves, as I believe they have, although not, formally or publicly, to stipulating that their papers will not be released until everybody they've served with is either off the court or dead, however they choose to frame it. The Warren Burger papers, for instance, Burger's tenure was roughly contemporaneous with Blackmun's, are not going to be open until 2026. I can hardly wait.
When I was clerking, it never occurred to me that memos that I wrote to Justice Powell would find the light of day. And then I read an article by you on Plyler versus Doe, in which you're citing to a memo that I did write to the justice.
Oh, the Powell papers are great. I mean, Washington Lee built a whole wing of their library for the Lewis Powell papers, and it's hard to get to because it's hard to get to Washington Lee, but that they are. I mean, I recommend it to anybody who's interested in recent Supreme Court history. That is a great set of papers.
But I'd like to ask Jamal, as a pretty recent law clerk, did it ever occur to you as you were writing a memo to the justice that you were probably writing this memo Linda Greenhouse as well?
Well, I clerked after Becoming Justice Blackmun came out, so it was perfectly obvious that I had to be very careful about what I said. So,
You have a right of privacy.
That's right. I do have a right to privacy. No, I think the clerks recognize as much as the justices that what they do is going to be part of history going forward. And I think Justice Stevens, I don't remember exactly what his rule is, but it will be for another, at least another couple of decades before anyone sees the terrible things I've written.
Professor Semmel, it might be interesting to hear you reflect on the intersection between Justice Stevenson's view on racial equality and his death penalty jurisprudence.
I think it's an interesting question, and I have to say somewhat puzzling for me in certain respects. In his opinions, whether they are concurring, majority, or dissenting, his critique of the death penalty, beginning with Gregg, it does center very much, is very conscious of how much a part of the death penalty, in the institution of the death penalty, race discrimination is. And I think certainly his adoption of Justice Stewart's narrowing approach was at least inspired by the belief that narrowing would or could ultimately, if not cure, greatly reduce the adverse effects of race discrimination in the imposition of the death penalty. But it's interesting to see that it hasn't been, I guess I would say, as seminal or as central, at least to my estimation, in his jurisprudence as it was for other justices, Marshall perhaps most pointedly. And even when you take a look at Justice Breyer's decision in Miller L. To join Justice Marshall. Justice Marshall in 1986, when Batson was decided, concurred in the judgment that peremptory challenges could not be used in a discriminatory fashion, but he wrote that the only cure for race discrimination in jury selection was the elimination of peremptory challenges. And it wasn't until Miller L. that Justice Breyer came on board and adopted that view. And other justices have expressed an interest in that view. Justice Stevens, in public comments, has expressed, I think, an inclination to go in that direction, but he hasn't formally done it. And it just strikes me, and I'm not sure that I have the sort of the full analysis of this or the full weight of this, that it's interesting that despite his consciousness of the effects of race, the invidious effects of race in the death penalty, that he hasn't gone quite that far. So I think the last comment I would make is that I think Snyder is the decision in Snyder, which is the most recent Batson decision, in which Justice Stevens was a very vigorous questioner during oral argument about racist comments by the prosecutor, race discrimination in jury selection, etc. The opinion in Snyder is a very stripped down, I mean, it could not be a more bare bones opinion in which the court basically hones to the law that discrimination in jury selection is not permissible. But if you didn't know more about the case because you'd read the briefs or you engaged in it, you almost wouldn't know that it was a case about race discrimination. You wouldn't know the defendant was black. You wouldn't know all of the African-American prospective jurors were struck. My suspicion, and it's only that, is that had a lot to do with Justice Stevens' negotiations, shall we say, on how to assemble a 7-2 majority in that case.
Jeff, you've been so important in the last few cases that have turned the federal sentencing system, have shaken it, let us say. And that's part of what I want to ask you about. What would you say that Justice Stevens' ideal sentencing system would be? Would it be a return to the pre-guidelines system that we had, or does he have something else in view, or can you say?
It's a great question, and actually, if I can say one word about his capital jurisprudence that I think Liz your comments brought to mind for me something that I just admire so much about the justice. The three recent opinions where the court has ruled the death penalty out of bounds in certain kinds of cases, Atkins, Roper, and most recently Kennedy. Atkins, of course, was the first, and it was the Justice Stevens opinion. And I think it's a fascinating opinion and a real tribute to his method of judging. I said before, he's a common law judge. And in a similar way, what I was thinking when you were talking was that Justice Stevens is also so comfortable being a judge. He's comfortable with the idea that judges have to make hard decisions and judges have to bring their values to those decisions. And having litigated the Kennedy case most recently, and I sort of read the text of the Eighth Amendment about 500 times before you go up with the argument, it says it prohibits cruel and unusual punishment. And if there's ever a clause in the Constitution that actually invites judges to bring their own values and what they think the society values are to decision making, it has got to be the Eighth Amendment. I mean, there are some provisions of the Constitution that are fairly plain on their face, and I think you can argue need to be interpreted apart from the judge's own views. But the Eighth Amendment seems, at least on some level, in some way, to invite judges to use their own views of the world. And what's interesting to me, and I think Atkins is the first opinion that I think, at least in the modern court, where the justices actually embraced that concept of the Eighth Amendment. And I think Justice Stevens, while as I said earlier, gaining plenty of heat from the other side of the bench for doing that, I think not only felt justified doing so in the text of the amendment, but I think just really feels comfortable doing that. I think it's a tribute to his method of judging. So the question about the current, the non-capital sentencing regime, in particular in the federal courts, and what Justice Stevens would like to have. Of course, I don't know. He told us to some degree, at least starting from a system of guidelines, how he would like to use that system. Because in Booker, there wasn't just the constitutional holding that the federal sentencing guidelines were unconstitutional as they were being applied in courts across the country by letting judges make various decisions. There was also the part of the Booker that said, what are we going to do about it? And here, Justice Stevens actually found himself in the minority. And the majority of the justices, led by Justice Breyer, decided to make the federal sentencing guidelines advisory. And so we now have a regime where they need to be consulted but not necessarily followed. Justice Stevens said what he thought should happen as a remedy for the constitutional violation was we should just leave the guidelines in place but have the jury have juries make the findings that trigger the various upward and downward adjustments under the guidelines. And so I think that there again, Justice Stevens is putting his faith in the jury as a bulwark between the individual and between judges, or between the individual and between government. And so I think that there's something powerful that he would like a sentencing regime that does separate certain kinds of conduct and certain kinds of offenses. So we give sentences to offenders based with more particularity on the kinds of conduct they committed, but we assign to jury the task of making those threshold findings, not to a court. But at the same time, I can't say with a lot of confidence that if he were a legislator, that he would draft that kind of a system. He's certainly said as a judge that if a legislature came and adopted a system where wide ranges, like the previous federal sentencing regime, where wide ranges were allowed and it was really up to the judge to decide what sentence was most appropriate within that range based on whatever facts the judge deemed appropriate, then at least he's unwilling as a matter of constitutional law or as a judge to invalidate that kind of a system. Justice Stevens has said, and he said this actually in a footnote in Apprendi, and he's talked about in other places, that he would rely on the political process to address a situation like that. And so I think that's an example of Justice Stevens as he's called himself on various occasions as the conservative judge, the sort of small c conservative of I'm not going to go out of my way to impose what I think is the ideal system on everybody else. So
just to follow up on that a little bit, what we have in the federal system, and I think if you were describing it, the statistics I'm sure would bear me out, is we don't have a jury system. We have a plea bargaining system, and I wonder whether, and that's the true background on which this debate occurs. And there's a sense in which the debate, I don't want to say it's irrelevant, but this background is what's critical, at least if one is concerned about the main case, the average case, the typical case, because the vast proportion are not going to get to a jury one way or the other. And I wonder, does Justice Stevens, in any of his opinions or in any of his extra judicial writings, has he ever reflected on the plea bargaining system and how that diminishes the role, but both of the jury and to a degree of the judge as well?
Yeah, it's a great question, and one that I think I have to say I'm not familiar with any writings or public comments that Justice Stevens has made about plea bargaining, at least not in this context. I suppose if he were asked, one thing he might answer is that plea bargaining, of course, happens in the shadow of the law, and to what would be required if the case went to trial. And so I think one answer is by giving the defendant the right to at least in the plea bargaining process say, well, if you're going to want to get me sentenced for that too, you'd have to prove that to a jury, rather than being, I think, a slightly weaker situation of saying, I don't think I should be punished for that, but I realize it would be up to the judge. Then I think you might say that even though, as you say, 90+% of these cases are resolved by plea bargains, it might be that defendants in a system where they have the right to jury trial for the various findings are able to use that jury trial right as a bargaining chip and a lever to get more appropriate plea bargains.
There are a lot of judges in the room, and I don't know whether they would agree with me or not, but when I hear you say that the jury in a sentencing proceeding would be the bulwark behind which a defendant could secure his or her rights as against the judge, this sounds odd to me, and it's not. I mean, we all have our own view of the world, I suppose, and our view of how criminal litigation operates. But I would say that that's probably not a tension that I've either witnessed as a prosecutor or as a district judge. I would think, and the reason I asked the question about the more open-ended system is in a more open-ended system, the judge frequently exercises a degree of mercy, or may take a chance on a defendant because the defendant has put on a certain amount of information. It might not rise to the level of preponderance, but it seems in the circumstances reasonable to rely on. Whereas the more you legalize that and make it part of a adversary presentation to a fact-finding body, I think you might lose something very, very significant from the point of view of a defendant.
Well, I want to be clear that I certainly, in my work, have never advocated sentencing by juries. Nor do I think the cases that the court has decided require juries to determine sentences. I think what the right is about, as the court has articulated, as Justice Stevens has articulated, is the jury is a bulwark in the sense that it is a hurdle that the prosecution needs to get over in order to impose a sentence, and is a prerequisite to a judge imposing a certain kind of a sentence. But nothing about the jury making that threshold necessary finding requires the judge to impose the stiffer sentence, or indeed prohibits the judge from exercising mercy. Now, you might say that when you add this layer of adversary system on top of it, and the case comes to the judge with this finding already made, rather than leaving it to the judge to exercise perhaps less transparent discretion, then you, in certain cases, are going to disadvantage defendants. And I think you just have to say, in other cases, you're going to advantage, and it becomes I'm sure you, as a judge, would have
hard to say.
But again, it comes down to whether you think that this should be a prerequisite. I think not the end of the line.
Let's see if the panelists have any questions for one another, and then we'll open it up to the audience.
I want to just add, when we're talking about jury versus judge sentencing, that we need to distinguish, as always, capital cases, because of course an open question remains, will the court go so far, which it clearly hasn't done, as to require that in capital cases the penalty phase, the sentencing decision, have to be made by a jury. And there I would say that indeed the jury is the bulwark between the defendant and the power of the government. And if we look at a state like Alabama, which is one of the few states where a judge can still override a jury's verdict. Indeed, in Alabama, a jury doesn't render a verdict, it renders only a recommendation. In Alabama, we have 25, I think just about 25% of the men and women on death row in Alabama received a recommendation of a life sentence from a jury, which was overridden by a judge. And one of the things that Justice Stevens has written about, I think so eloquently and passionately in his opinions, in his critique of the death penalty, has been the role that judges have played in the deprivation of fundamental rights, that is, judge sentencing has played in the deprivation of fundamental rights in the death penalty context.
I just had a quick question for Liz, actually, having to do with just your instincts about Justice Stevens's the view he articulated in Bays and how it would look like, what it would look like going forward. If you actually had a case in which a petitioner in a capital case actually, let's say the court grants a question presented that actually has the constitutionality of the death penalty in it, and it is argued in the briefs and at oral argument. I mean, I can understand why, for prudential reasons, why Justice Stevens would not necessarily take the same position as Justice Marshall and Justice Brennan and Justice Blackmun in terms of dissenting from denials of cert and dissenting from stays. There are other considerations, equitable considerations, and so forth. But if it were actually squarely presented to him, I don't know from his opinion in Bays what the answer to that is, and I just wonder what your instincts are.
Well, from his opinion, I mean, he says very clearly in Bays that he defers to the precedent of the court, and he is very much a judge who has put a great deal of value and weight on precedent. And so I think it was very intentional in Bays, even though his conclusion was clear, and even though I think one could make the argument that it was the moment to dissent, that he did not because of precedent. So I guess I would say I remain hopeful but not optimistic that he would necessarily take the Blackmun step. And one reason, which I am really ill-qualified to speculate about, but others I think have alluded to, is that he continues to be an active member of the court and that he continues to play an active role in the conversations on the court, in the shaping of majorities, etc. And so I would simply raise a question to which I don't know the answer, how much he would feel that his influence, were he to take the Blackmun step, and Blackmun took that step very shortly before his retirement, would diminish that influence. Now, that is a very sort of pragmatic analysis, but I think it's probably, I would suspect it's one that he's thought about more than once.
Actually, can I pick up on that? And I was going to ask Linda a question. A lot of your paper and some of your writings in the later years in the Times talked about Justice Stevens as the strategist on the court, putting together majorities and working behind the scenes. And of course, there's another view of Justice Stevens, particularly when he went on the court, which was in some ways the opposite. It was Justice Stevens, the independent thinker, and this is sort of the transparency view of I'm just going to say what I think and I'm not going to try to mold my view or mold others to like it. And so I guess my question for you is, do you think Justice Stevens has, in a sense, evolved in that sense of his behind-the-scenes workings in the court, perhaps as he's risen up towards the current position of senior associate justice? Or do you think Justice Stevens was to some degree misunderstood in his earlier time on the court?
Well, of course, this raises the whole fascinating question of, do justices evolve on the court and in what ways? And with respect to Justice Stevens, has he changed? He says not. He will say publicly, I haven't changed, the court's changed around me. So it's a kind of a dynamic process. But yeah, I mean, I think a couple of contingent factors. I mean, both becoming the senior associate justice, so having the responsibility for assigning an opinion in which the chief is in the minority, and the moving to the right of the court as a whole. I mean, it's Justice Stevens who's made the observation that in modern, I forget how long back he goes, 25 years, every justice who's filled a vacancy has been to the right of the justice whose vacancy they filled. So he's responding to that, and I think his sense, I mean, it's reflected in his response to the abortion cases. He's not only a common law judge, he's a common sense judge. He's a common sense person. And when he sees things just kind of running off the rails, I think he, calls on his great intelligence and care to try to bring things back to some kind of mainstream. And so I think all of those factors did lead to a change in his own conception of his role. And I wanted to ask you a quick question. So there's a chain of cases between Apprendi and Booker, right? So Apprendi says, I think there's a footnote or a passage or something in Apprendi that says, of course this doesn't apply to the death penalty, right? So then we get Ring against Arizona, which overturns Walton and does apply the Apprendi principle to the death penalty. And there's a footnote in there that says, of course this doesn't apply to guidelines. So then you bring up Blakely against Washington, the state guidelines, and the court says, of course, we're only dealing with state guidelines. And then, of course, you get Booker and the federal guidelines. So when Justice Stevens conceived of and wrote Apprendi, did he have all of this in view, or was this just the common law at work?
If I were to guess, I would say that Justice Stevens was well cognizant of the road ahead when he did what he did in Apprendi. And of course, in Apprendi itself, he had the particular challenge of getting around Walton because it was a precedent. So when they said this doesn't affect the death penalty, in a sense, that was a stare decisis comment as opposed to the other ones you've made. But I think that Justice Stevens has well appreciated, I think as his early dissents in Walton and McMillan show, he's well appreciated what he viewed as the ultimate appropriate arc of this right. And then once you get past Apprendi and Ring, I think each of the footnotes you're talking about are just the court taking one step at a time, realizing that each of those steps themselves are fairly significant steps, and we're gonna reserve each subsequent question for the next case.
Okay, we have time for one short question and one short response, so make it a good one. Yes, sir.
Please stand. Thanks.
Hi, I'm John Oakley from the faculty here.
It has to be short, John.
All right. Linda, would you remark upon one contribution of Justice Stevens to the jurisprudence of abortion that hasn't been mentioned, that starting with Thornburg in '86 and most clearly developed in Webster in '89, he called attention to the religious cast of claims of state interests in fetuses before viability?
Yes, it's in my paper, but I left it out. So, as mentioned in Thornburg in '86 and then Webster in '89, the Webster decision involved a Missouri statute that had a preamble that said life begins at conception. And the majority in Webster, the plurality in Webster, Rehnquist says, well, we pay no attention to that. That's just, verbiage. And Justice Stevens says in his opinion in Webster, we've got to grapple with that. It's in the statute, and it's a governmental embrace of a particular religious orientation toward the meaning of life, and that violates the Establishment Clause. No one ever joined him on that, but it's a really provocative, interesting, and I think very useful framework for looking at this issue.
Well, let us thank our wonderful panel.